When you apply for a US Entry Waiver, the last thing you want to get is this letter from the US Customs and Border Protection saying, "We must inform you that we are denying your application." What makes the situation worse is that this was preventable. And the reason why has to do with eligibility. I'm Dan Joffe, US Waiver Lawyer. If you're looking for expert advice on traveling to the United States without stress, schedule a free call with me using the link below. Let's get started. This letter is from someone who approached our law firm about their denied waiver application. This denial happened because the applicant wasn't eligible yet. They applied too soon. It's a common and expensive mistake that people make. I'm going to explain the nuances of eligibility and timing, and I'm going to give you 3 essential tips to ensure that this doesn't happen to you. A key question people want to know is, when am I eligible to get a US Entry Waiver? Unfortunately, there are no set eligibility timelines telling you when you are eligible. The Admissibility Review Office, which is part of the US Customs and Border Protection, makes the decisions. One of the key factors they consider is the risk of harm to society if you're granted a waiver. A key factor for the ARO's decision is the time since your conviction. However, they focus not just on the date of your conviction, but also on when you completely fulfilled your penalty. The more time that has passed, the less risk you pose to society. But it's not just about time, but what you've done in that time. The ARO wants to see what efforts you have made towards your rehabilitation. Genuine rehabilitation takes time to prove that you no longer pose a risk of committing future criminal acts. With this denial letter, this applicant applied way too soon. They were still under court probation in Canada, which means they hadn't even finished their sentence. From the ARO perspective, there is no chance that this person could be properly rehabilitated because real rehabilitation and reformation takes time. And that simply wasn't the case here. If this person came to our law firm before their application, we would never take on this case because the application should never have been submitted. To ensure that you don't make that mistake, here are 3 essential tips to avoid denial. Tip number 1, get a legal assessment. Every case is unique. Your eligibility depends on your specific situation in the context of US immigration laws. Get that proper analysis based on legal grounding to find out your eligibility timing. Tip number 2, work on your rehabilitation. If you have recently completed your penalty, work on your rehabilitation. You need to prove to the ARO that you have changed, so use your time wisely. Tip number 3, get professional legal help. US entry waivers are a specialized area of US immigration law. Properly navigating that legal complexity is critical to maximizing your chances of a successful waiver application. If you need expert legal help with your US waiver application, reach out to schedule a free confidential call with me.